Welcome to participants from around the globe to this final webinar for 2024, organised under the auspices of the UNESCO Chair in International Law and Cultural Heritage at the University of Technology, Sydney. The theme of our webinar today is Culture and Human Rights, a Year in Review, and I extend the warmest welcome from the Southern Hemisphere to our esteemed panellists in the North. We are grateful that they have accepted our invitation at this busy time of the year. This event is an opportunity for practitioners and scholars to hear from members of the key UN human rights bodies working in the field before the close of 2024. On issues concerning culture as a global public good following the UNESCO World Conference on Culture and Arts Education earlier this year, the UN Summit for the Future held in New York recently, and in the lead up to the global report on cultural policies being prepared for Mondiacult Barcelona next year, and the updating of the SDGs. In this context, we know that the final declaration of Mondiacult 2022 in Mexico City identified 6 priority areas. They are cultural rights, culture in the digital age, the cultural dimensions of climate change, cultural economics, heritage in crisis, illicit trafficking and destruction of cultural property, and integrating culture into education. These are the focus areas of the global report, and no doubt we will be discussing some of them during our panel discussion today. Focusing on the current mandates and recent work of their respective UN human rights bodies, our 3 panellists will provide vital, practical insights on their contribution to our understanding of the role of culture in human rights law. Before I introduce our first panellist, a bit of housekeeping. First, panellists will be presenting for 10 minutes each. This will enable a period of Q&A at the end of the final panellist's presentation. Attendees are asked to pop their questions that they may have for the panellists into the chat function. This will be put to the panellists at the end of the last presentation. The recording of this webinar and information about the program will be available on the UNESCO Chair website, links to which will be provided to the participants after this event. So let me begin by introducing our first speaker, the current UN Special Rapporteur in the field of cultural rights, Professor Alexandra Zantaki. Professor Zantaki is Professor of Law and Director of Research at Brunel University, London, in the United Kingdom. She completed her law degree at Athens Law School and undertook her doctoral studies at Keele University in the field of the rights of Indigenous peoples. She is a member of the Oxford Summer Human Rights faculty and founder of the Athens Refugee Project. Professor Zantaki was appointed UN Special Rapporteur in 2021 and is only the 3rd person to hold this post since its establishment over a decade ago. Since taking on this role, she has considered several themes of vital importance to the current concerns of the international community and for many peoples within and across states facing unprecedented change, economic, social, political, and environmental. She has addressed development and cultural rights, migration and cultural rights, and more recently, the right to participate in science and sport. Professor Zantaki has long manifested a dedication to the promotion of culture in human rights law, particularly those of Indigenous peoples and minorities, over many years. Welcome, Professor Zantaki.
Thank you very much. And thank you very much for the invitation. As I was saying earlier, it is amazing to be in the company of such great individuals. We don't have time to talk among each other very often. So what the mandate has been doing in the last year, I continue to be very focused on explaining directly and indirectly to states and to the world that the scope of culture. I think traditionally culture is seen either as cultural heritage or as artistic freedom, and a lot of emphasis have been going into these 2 aspects. And I fully understand that they should continue to flourish in scholarship and to be more emphasis on those. But at the same time, I want to emphasize during my 6 years as a special rapporteur that when we talk about culture, we talk about ways of life. So we talk about something much more much broader than the states usually understand. So you can see that in the topics that I chose to focus on. So I chose to focus on the right to participate in sports. And I also chose to focus on the right to participate in sciences as a way of showing that that indeed, when we talk about culture, the sciences and sports are included. And it's very interesting, my report on participation on sports, because I make clear in my report that when we talk about sports, sports are part of culture. So for any declaration or any document that says culture and sports, my report indirectly says that actually it should be culture including sports. So this is an argument that I hope to emphasize in the next year from now on. And then I also focused, of course, on the scope of cultural rights. And for me, it's very important to discuss participation. And that's why you can see this is an ongoing theme in my reports, the right to participate in sciences, the right to participate in sports, etc. And also when I talked in the 2 reports on development, I focused a lot on participation. And I explained what I mean by participation, and I explained why participation is very much an element of the cultural rights approach. And this was done in the reports, as I said, but also in my state visits. So last year I went to Chile, and I just came back from Laos last week, where I completed my 3rd state visit of my mandate. And in both states, it became very obvious that cultural rights and the right to participate is a continuing weakness. In Chile, I found out, and the report is going to be discussed in March, but my preliminary observations already have said that there is no overall recognition, generic recognition of the right of everyone to participate in cultural life, and the focus is on specific groups. So there is a focus maybe on some indigenous peoples, and even that, of course, is problematic, but there is a focus on that, but there is no overall recognition of the right to participate in cultural life. And also in Laos, my preliminary observations that were conveyed to the government last Friday have been that there is indeed no clear understanding of what we mean by the right to participate. And also, I think that a lot of states feel that, the right to participate has to be linked to the cultural life, whereas the Committee on Economic, Social and Cultural Rights in General Comment 21 of 2009 expanded that and said that, we talk in general participation in all parts of life that have an effect on cultural rights. So these are the 2 elements that continued throughout the 2 themes that continue throughout my 6 years, and I'm now in the 4th year. But also I have been very active when it comes to the culture as a standalone goal, and together with civil society in the post-2030 agenda, and together with the civil society, we work and UNESCO, we work quite intensely on convincing states that culture should be a standalone goal. I have to say that so far, I don't feel that we are winning the battle, but it's still early, I hope, and I hope that our efforts are going to be intensified, especially with more states that become allies. So, I think that we have a very firm commitment by civil society, and there is a very firm commitment by UNESCO and by my office, but not, we don't have a lot of allies among states. And I think it is very important because states would say that, well, culture should be cultural rights and culture should be protected in all mainstream throughout the other SDGs. However, we have seen that this has not happened. And I saw that very clearly in Laos. In Laos, there are no targets about protection of culture and cultural rights. There are no indicators. There are no specific goals. So this unfortunately is the case in most states. So that's why I think it is really important to fight in order for culture to be included. Not culture and sports, culture that includes sports, as international law has done so far anyway. And also I have worked quite closely with UNESCO. I think that sometimes it has to do with personality, sometimes it has to do with topics, but this, you know, my office at the moment is quite close to the UNESCO section on culture, and we work very well together. I see how UNESCO is pushing more and more on cultural rights, which is fantastic. I try to explain in general to people what is the difference between UNESCO and the United Nations. Again, I feel that there's more work to be done on making everyone understand that UNESCO, the core of UNESCO is the protection of culture and cultural heritage. My core aim is the protection of the right of cultural rights. Hopefully the two are together, but unfortunately sometimes they're not, and we can see this unfortunately in conservation, in the area of conservation. But you know, so far we are working together. I am particularly, what I'm trying to do is I'm trying to go to several committees of UNESCO and explain to committees why it is important that their work does not go against, does not limit cultural rights. And I have done so. I have gone to the committee of the second protocol of the Hague Convention, and we have signed a statement about this, and I'm going next Tuesday to talk to them again. But the intergovernmental focus and strength of UNESCO sometimes acts as an obstacle in civil society getting more say, but also for me to be able to convince states to push for human rights and especially cultural rights. My mandate has focused quite a lot on development. We had previously, before 2024, we had 2 reports on development, linking development with cultural rights, and putting forward the idea that sustained, self-identified, self-determined development that does not fit one-size-fits-all model cannot happen if we don't take into account cultural rights. And then I focused on the governance, the international governance, and in essence, how they ignore cultural rights. This could not be more obvious than in my state visits in Laos. I think that UN agencies beyond the human rights and maybe UNESCO find it, and indeed UNESCO, find it extremely difficult to understand and to use the human rights methodology and the human rights language. I think this creates huge problems as we speak to the cultural rights of the indigenous peoples, but also of local populations and minorities and marginalized groups. And I have seen that very clearly in the state reports, but also in the communications that last year I have sent to states, discussing in private, but also then publicly their acts that I perceive as violations to cultural rights. And finally, when we talk about climate change, because I think that, Chair, you talked earlier about climate change, my report on the right to participate in sciences contributes. I mean, there is a report some years ago on climate change and cultural rights, but my report on participation in sciences contributes, I believe, quite substantially in how climate change should be tackled, definitely with effective participation and leadership of indigenous peoples and people on the ground rather than the experts only. And an ongoing battle is that of assimilation. You can see that we focus a lot on assimilation in my communications. This year it was Tibet, Iran and how cultural rights in Iran are pushed down and identities are assimilated, and as always, indigenous peoples. So this has been my my year. Thank you.
Thank you very much, Professor Zantaki. I'm sure we'll come back to you when we have the Q&A because there'll be many questions coming through. And welcome now to Professor Dali Sambodora. Professor Dora is the current Arctic region member of the UN Expert Mechanism on the Rights of Indigenous Peoples. She was involved in the negotiation of the UN Declaration on the Rights of Indigenous Peoples for many years prior to its adoption by the General Assembly in 2007. She was chairperson and expert member of the UN Permanent Forum for Indigenous Issues from 2011 to 2016 and the UN Voluntary Fund for Indigenous Peoples from 2009 to 2014. Prior to taking up her position at the expert mechanism, Professor Dora was the international chair of the Inuit Circumpolar Council. She was also chair of the International Law Association's Committee on the Implementation of the Rights of Indigenous Peoples, which overlaps with her most recent work with the expert mechanism. Professor Dora is senior scholar and special advisor on Arctic Indigenous Peoples at the University of Alaska Anchorage, where she was previously engaged as a professor of international relations. She holds a PhD from UBC Law School and a master's in laws in law and diplomacy, arts, law and diplomacy from Fletcher School at Tufts. There are numerous awards that she has been given in acknowledgement of her contribution over so many years. Professor Dora has worked tirelessly for the articulation and effective realisation of Indigenous people's rights, including the right to culture. Most recently, in particular, of particular interest to us today is her hard work in relation to shaping the global response to the climate crisis for the benefit of Indigenous peoples, including at the COP negotiations. We are honoured to have her as a foundation collaborator on the UNESCO chair. Professor Dora, thank you for accepting our invitation and welcome.
Thank you very much, Anna, for the invitation. And as Alexandra has said, it's really wonderful, despite the diverse hours that we're engaging in this gathering. It's wonderful to connect with good friends and colleagues. What I'd like to do is focus on 3 different topics that I've been engaged in. There's quite a lot to cover, but I had better narrow it down. First of all, I want to say that everything, at least from the perspective of Indigenous peoples, is about culture and cultural identity and distinct cultural rights of Indigenous peoples. And I think it's often overlooked, especially because UN member states love to address culture, but not within a rights framework. You know, they love to see the happy dancing natives, but when it comes down to recognizing the interrelated, interdependent, interconnected, and indivisible nature of culture and all of our rights, including the right of self-determination, it's the UN member states find it indigestible. So what I'd like to comment on quickly is developments and a gathering that, in fact, Alexandra was also involved in, a workshop focused on the World Heritage Convention and the activities related to that workshop in January earlier this year. And also I'd like to touch upon the UN Framework Convention on Climate Change a bit and mechanisms that are not often referred to by Indigenous peoples. And I think that we have to start adding these various different mechanisms to to the list, because it's very common for everyone to refer to the Expert Mechanism on the Rights of Indigenous Peoples, the Permanent Forum on Indigenous Issues, and less so on the International Indigenous Peoples Forum on World Heritage, or the International Indigenous Peoples Forum on Climate Change, for example. And then I'll close with some comments about the so-called just transition that everyone is commenting on. And before I launch into that, I think it's important to point out in each of these examples, I think that Indigenous peoples themselves have taken a multi-pronged approach to invoking human rights standards in order to safeguard their culture, in order to safeguard their cultural rights. And I think this is really significant. And by that, I mean at various different scales, at the micro level, on the ground and closest to community, at the regional level, the national level, and at the international level. And I think this is an important dynamic to successes that we've seen in a number of different areas. But it also means that Indigenous peoples have to ensure that those that are being represented, especially within the treaty bodies and elsewhere at the international level, that they fully understand what is happening in terms of their rights to culture, from the macro to the micro. Too often I think we hear Indigenous people say, what is the point of engaging at the United Nations when our issues are right here in our backyard? And this is why I think it is critical that the multi-pronged approach is important. So in relation to this workshop concerning the World Heritage Convention specifically, Indigenous peoples address concerns regarding the nature-culture divide in the World Heritage Convention and the lack of recognition of Indigenous heritage values. And participants, of course, pivoted on the UN Declaration on the Rights of Indigenous Peoples, and in particular, Article 31. And the whole effort of the workshop was to compel UNESCO to alter its policies and procedures regarding Indigenous peoples and their direct participation in the work of UNESCO. And specifically, Indigenous worldviews, and I think the conclusions and recommendations of the workshop were very clear that Indigenous worldviews and perspectives are largely absent in criteria that UNESCO and those engaged in the World Heritage Convention, all the activities swirling around the World Heritage Convention, the criteria of, for example, outstanding universal value, which doesn't take into account Indigenous people's understanding of culture when it comes to this important relationship between Indigenous peoples and their lands, territories, and resources, and specifically their rights to lands, territories, and resources. But there are all kinds of other detailed problems in terms of the lack of transparency, the lack of mechanisms for the direct involvement of Indigenous peoples. The outcome of the workshop highlighted numerous demands, including the need to respect Indigenous people's human rights, and specifically the UN Declaration on the Rights of Indigenous Peoples. It's stunning to me that you have a UN declaration, an important international human rights instrument that was drafted through the UN process, but you have agencies engaged across the globe that don't believe that it even applies to them. And UNESCO and, well, specifically the World Heritage Convention itself, there's a resistance to actually embracing what UN member states adopted on September 13th, 2007. But the lengthy workshop report did make numerous demands, including the important recognition of Indigenous cultural values in the criteria of outstanding universal value, also establishing an effective grievance mechanism, respecting the right of Indigenous peoples to free, prior, and informed consent when it comes to, again, the substance and the process of the World Heritage Convention. I won't get into all of the details, but it was an important gathering that attracted Indigenous peoples from across the globe. And the outcome document, the intent of the outcome document was for its delivery to the most recent meeting concerning World Heritage. And I won't get into the politics and what unfortunately didn't happen during the meeting in New Delhi, India, but it remains an important outcome document in terms of the workshop. Turning quickly to climate change, I just want to point out two different events that myself as a member of the Expert Mechanism on the Rights of Indigenous Peoples was involved in, and that was the country engagement requested by the Sami people in Norway, and our participation in the work that they're doing. Many may be aware of the huge protests that were held last year over the wind farms and alternative energy, renewable energy in Norway. What many may not be aware of is the work by the Sami themselves, and this is the multi-pronged approach that I was referring to, as the activity out there and on the ground in terms of the very public protests, but also litigation that they undertook, as well as a request to the Emirate for a country engagement to look more closely at the issues and the cases, but also the lack of response by the government of Norway to the cultural rights of the Sami people, which are, of course, attached to lands, territories, and resources, as well as their right of self-determination. But what I wanted to point out was in the course of this multi-pronged strategy that they undertook, the Supreme Court in Norway ruled that, consistent with interpretations by the Human Rights Committee, that Article 27 and the right to enjoy their own culture, the Sami people specifically, that was invoked by the Supreme Court. So the International Covenant on Civil and Political Rights and Article 27 specifically was affirmed by the Supreme Court in Norway, where they refer to the fact that it is clear that the Sami people are a minority within the meaning of Article 27, and that reindeer husbandry is a form of protected cultural practice. And so it's an important example of cultural identity and ties to lands, territories, and resources. The other case, of which many, I am certain, or I hope, in Australia are familiar with, and that's the Torres Strait Islander case and the Human Rights Committee's reaction and response, and their review and assessment of the government of Australia and their failure to adequately protect the Torres Strait Islanders against the adverse impacts of climate change. And this is really interesting to me as an Inuk, because some years ago, you may be familiar, or many may be familiar with Inuit taking a human rights case to the Organization of American States and the Inter-American Committee on Human Rights, and the fact that there was no real causal linkage, and that was the outcome. I think it's really important that at least the UN Human Rights Committee took the claims of the Torres Strait Islanders very seriously, and did in fact conclude in favor of Torres Strait Islanders. I don't want to get into it too much, because I know that your audience is probably definitely familiar with this particular case. Before I leave the issue of climate change, I do want to point out that the International Indigenous Peoples Forum on Climate Change has done really significant things, and I see it as a mechanism. In fact, it's the only mechanism that presently exists within the UN itself that doesn't require the oversight of states for the selection of Indigenous peoples representatives to the forum. Unlike the MRIP or the Permanent Forum, where you get the Good Housekeeping seal of approval from the Human Rights Council president, or at the General Assembly for purposes of the Permanent Forum, but that Indigenous peoples select the individuals. But what I wanted to point out there is that over the past year, the Internet, I'll just call it the Indigenous Peoples Caucus rather than the lengthy title that it has. They prepared a really significant report about the impacts of climate change on Indigenous peoples. They did so in collaboration with the Center for Environmental Law. And the report is substantial and gets into the area of climate finance, sustainable development, but more significantly, the demand that Indigenous peoples and their communities are not consistently treated with the colonial practices that actually created many of the problems that we all face because of climate change, including things like the lack of consent and dispossession of lands, and numerous other conflicts that have emerged. A few other things happened in relation to the UNFCCC. The UN Secretary General also pulled together a whole discussion on critical energy mineral transition. And I'll conclude with these remarks about so-called just transition. In the Sami case in Norway, over the wind farms, this is an area where renewable energy doesn't neatly align with the interests of Indigenous peoples. And in terms of just transition, I think it was quite significant that the UN Secretary General invited Indigenous peoples to participate directly in a UN panel on critical energy transition minerals. And we were fortunate to have two Indigenous representatives that joined that dialogue and influenced the outcome, not to the extent that we had hoped, but nevertheless, at least the Secretary General in this discussion about just transition did in fact pause and engage Indigenous peoples directly. And of course, they invoked the UN Declaration on the Rights of Indigenous Peoples, the right of self-determination, free, prior, and informed consent, but importantly, this dynamic of the profound relationship that Indigenous peoples, as a part of their culture, that they have to their lands, territories, and resources. The outcome document there from that panel on critical energy transition minerals is available. In fact, all of this material is available on the internet for those that want to look at more of the details. Those are just a few of the things that I've been engaged in as a member of MREP, but also as a human rights advocate in favor of my own people as well as Indigenous peoples elsewhere. So I'll stop there. I have a lot of other notes, but I'm not going to look at it any longer. Thank you.
Thank you, Professor Dora. And nobody would know that it's nearly the middle of the night your way and that you're tireless. I think I always end with one of your presentations say that you're completely tireless. It's extraordinary. So thank you. And I'll now move on to our final panelist, Professor Yvonne Donders. She is a current member of the UN Human Rights Committee until 2026. Her nomination was overwhelmingly endorsed by member states when it was put forward. She's a professor of international human rights law and cultural diversity at the Department of International and European Public Law, where she was previously head, and director of Amsterdam Graduate School at the Faculty of Law at the University of Amsterdam. Professor Donders has held many leadership positions in the field of human rights, including Commissioner of the Netherlands National Institute for Human Rights since 2019, the Dutch national monitoring body, the chair of the steering committee of the Netherlands Network of Human Rights Research since 2017, a member of the Human Rights Committee of the Advisory Council of International Affairs for the Dutch Foreign Ministry since 2013. Her academic leadership in the field is reflected in her role as executive editor of the Netherlands Quarterly of Human Rights and board member of the Royal Netherlands Society of International Law for over a decade. Professor Donders completed her PhD on cultural rights and cultural identity at the Faculty of Law at the University of Maastricht. Her expertise and commitment to the field of culture and human rights is reflected in her consistently being called to advise national governments and intergovernmental organisations. We are privileged to have her as a foundation collaborator on the UNESCO chairs. Professor Donders, thank you for accepting this invitation and welcome.
Thank you very much, Anna, and the privilege is all mine. It's wonderful to be here with Dali and Alexandra to speak about the topics that are so close to our heart. And both presentations actually excellently paved the way for some of the things I wanted to share, mostly from the experiences that I see now at the Human Rights Committee, starting to underscore two of the things that they have said. And that's first of all, indeed, the incredible importance of the indivisibility and interrelation, interdependence of all human rights. So when we talk about cultural rights, we don't talk about only the right to culture. We talk about all the cultural dimensions, cultural aspects of actually also all other human rights. And therefore, they shouldn't be seen only as a separate category, but simply as human rights, in my view. The second point I would like to underscore is what Dali just called the multi-pronged approach to cultural rights protection. I think that's very important that from many sides, everybody has a role to play or a possibility to promote cultural rights, from whether it's from very local to actually the international level. And all of them together actually make hopefully some progress. Now, the covenant that the Human Rights Committee is monitoring is the Covenant on Civil and Political Rights. So many people think, oh, so there are not cultural rights in there. Well, exactly, indeed, what was already mentioned. There's many human rights in that treaty that have either a cultural dimension or actually name or explicitly refer to culture, such as indeed Article 27 on the rights of members of minorities to enjoy their culture, but also to practice their religion and speak their language. We also see, for instance, Article 19 on freedom of expression, that not only protects also expressions by artists, but also can be used by cultural rights defenders in order to protect their rights to freedom of expression. We have freedom of religion, Article 18. We have Article 17, which is the right to respect for privacy, family, home. All these elements are very important for many cultural issues. The right to political participation, Article 25. Article 26, non-discrimination, at the very basis of many of the issues we talk about. And not last, but certainly not least, our Article 1, which is the right to self-determination. Now, the Human Rights Committee has several means at its disposal. We have the views. There were already a few cases referred to, so the individual communications, whereby individuals or groups of individuals can bring cases to the committee after they have exhausted all their local remedies, the now remedies at national level. But I also would like to highlight, I will deal with a few cases in a minute, but I would also like to highlight we also have this reporting procedure whereby every member party of the treaty has to report to us, and it's now every 8 years, which sounds very long, but it's actually a very important process, has to report to us how they implement the treaty. And we enter into a dialogue with the states, but we do that mostly based on information by civil society organizations, by human rights defenders, by national human rights institutes, and those include very often indigenous peoples organizations or the indigenous peoples themselves or minorities, other cultural communities that bring us information on actually what is happening on the ground. And that is very important in our dialogue with the states. We can ask more critical questions, and we can then afterwards put the recommendations in what we call the concluding observations. And we hope that with those observations, the local civil society organizations, the human rights defenders, the indigenous peoples, they can hopefully use some of those recommendations in their strive for better rights. So what we see in the dialogues increasingly is that we address issues related to cultural rights, minorities, indigenous peoples, such as indeed effective and meaningful participation. And we see a trend nowadays that we use indeed the terminology that is used in other parts of the UN system, developed also in the United Nations Declaration on the Rights of Indigenous Peoples, such as the free, prior, and informed consent. This has been over the last years a common sort of terminology that we use, and I think it's very important that we use that terminology, which is not in our treaty as such, but which we took from, of course, all the developments in other parts, also in what the special rapporteurs have been doing, what has happened in other parts of the system. We talk about freedom of expression, the right to demonstrate. We just heard examples of demonstrations by indigenous peoples for their rights. So indeed, these kind of topics are addressed. As I said, protection of human rights defenders, including what we call literally indigenous peoples' rights defenders, for instance, or environmental rights defenders. So they form part of the general schedule of human rights defenders and thereby are supported by our treaty. We also can talk a lot about, and we do that in the dialogues with certain states, about demarcation, access, and use of land, which again, maybe not literally in our treaty, but from all the articles that I just mentioned, we gather that indeed these kind of topics are protected under our covenant, and especially in the dialogues where you can be a bit more broad and do not have to specifically say whether this or that article is applicable. We can talk about these issues in a somewhat broader sense. And a final topic for the dialogues that I would like to mention is discrimination, but especially intersectional discrimination and violence. We talk a lot with states about protecting, for instance, of indigenous women who suffer from such intersectional violence. Now, in the second part, just a few highlights on some of our cases. Indeed, on Article 27 that was just mentioned, we have quite a long-standing jurisprudence from which we have, now some lines of thought on Article 27. And I'm very glad, and indeed also heard about the case in Norway, that now national courts pick that up, because that would be, of course, the best, that nobody would need this international level if everything would be properly solved at the national level by using our jurisprudence, for instance. So indeed, indigenous peoples are rights holders under Article 27, whereas it speaks of minorities, and we all, of course, know very well that indigenous peoples are not the same as minorities, but at least they can use this provision also to protect their cultural rights. And that has been recognized by the committee a long time ago. Another important aspect is that it says the right to enjoy culture, but culture is here indeed seen as a very broad concept. Indeed, as Alexandra was referring to, the way of life, but very important, including economic activities and thereby land rights. So because these economic activities are not purely economic for many indigenous peoples, as we all know, they concern also their cultural identity and thereby are protected under this provision. And therefore, it's not that those rights are unlimited. There can be indeed instances where a state has to limit those rights, but then there has to be a reasonable justification, there has to be an impact assessment, and there has to be free, prior, and informed consent of the peoples concerned. And of course, that is where often the problems seem to be lying. So recently, what we've seen, therefore, in our jurisprudence is a few trends I would like to highlight. As I said, we use terminology that we didn't use before, say 10, 15 years ago. The UNDRIP, the Declaration on the Rights of Indigenous Peoples, is often referred to as a source of inspiration, as a source of interpretation, which is very important. We use free, prior, and informed consent. We use terminology of self-determination, a very sensitive and difficult topic for states, but also it happened to be for the Human Rights Committee. Many cases under Article 1, where self-determination is included, is not declared admissible because Article 1 is a true group right. It is a true collective right. It's the right of peoples to self-determination. And in my view, unfortunately, many years ago, actually, in one of the cases, the Human Rights Committee has determined, well, since this is a group right, it doesn't fit under the individual communications procedure. I think it was to avoid the whole issue of self-determination at that time. But now we found creative ways of saying, okay, we used Article 1, including its collective aspects, as an inspiration, again, as an interpretation tool for actually interpreting other provisions, such as Article 27. So that's very helpful. Now we see that we are now also dealing with newer topics, you can say, so the link between culture and climate change. Culture and environmental degradation is coming up in cases whereby we can link also culture to, first of all, the survival of the community. So it is linked to the right to private life and home, but now slowly but surely also to the right to life. Not the right to life, namely, according to our work, doesn't mean the right to be alive. It doesn't only mean that you can live, it also means a life in dignity and a life whereby you can live on the land and within the community or people that you are a part of. So we see that measures that are taken by the state or not taken by the state are linked to the very survival of peoples and communities. And finally, another issue related to that is that we link all of these issues to next generations, which of course, in terms of culture, is very important. That it's not only for now, but that also communities and peoples, minorities, should be able to hand over, to pass on their culture, their heritage, their identity to the next generations. Now, we've just heard about several cases. I'm just going to mention them very quickly because I see the time is running out. The case against Australia, indeed, on the Torres Strait Islanders, is one of the landmark cases. But more recently, we've had a case of Campo Agua indigenous community versus Paraguay, which was on environmental damage by a business company, an agribusiness, which used toxic sprays and banned chemicals. And again, we found a violation of the rights of the indigenous peoples there because they were not protected against that. We had a case against Australia in March 22, Roy versus Australia, where it was about participation in the determination of rights to traditional territory. So once again, we try to implement those issues. And in last July, actually, we had a case against Norway. It was on reindeer herding. It was not on climate change, but it was on the determination of rules on who could herd reindeer. And we had well, not the first time, but it's not often, we had third-party interventions by the Sami Parliament and the Sami Reindeer Herding Association, whereby we could say, well, it's actually the Sami themselves who prefer to have the rule like this and not like that. So, the government should truly follow that. Now, I would like to stop here and say that for all of this, what we need is information. The Human Rights Committee, unfortunately, doesn't do studies, doesn't go out in the world. We don't do that kind of visits. So we need the information from the ground. And I would warmly like to invite everybody to send us that information for either the reporting or to bring cases, because last October, actually a month ago, 2 cases in the Committee on the Rights of the Child and in the Committee on Economic, Social and Cultural Rights on the Sami in Norway were actually very successful. So again, keep that up, and then we can do our part from perhaps the very far level. I agree with that, but at least we can play our part. Thank you very much.
Professor Donders, thank you so much. Now I'll be able to open the floor up to questions from participants, which have slowly been gathering, but I need to encourage participants to type in their questions as well as we go along, rather than my monopolising questions to the panel. I'll put one which is probably controversial, that's been put by, not controversial in the sense of that it goes to the urgency of it, because there are so many issues within the world today, is the one put by Marjan. She's put several, but I'll choose the top one that she's put, is how are we safeguarding the right to participate to cultural life of Afghan women that have been now largely forgotten by significant parts of the international community since the withdrawal, particularly in relation to the restrictive domestic practices and social and political challenges faced there. Maybe a question to Alessandra, just to give Yvonne a bit of a breather.
Yes, I think this is why it's very important to see and to deal with cultural rights beyond the indigenous kind of, focus and the minority focus. And, everybody knows that I'm very fond of the indigenous focus, but I think it's very important I think what states tend to do is they tend to say, well, if we address indigenous cultural rights, they have cultures, we have arts. So if we address that, that's fine. I think that's why it's important to bring out more cases beyond the indigenous peoples that would strengthen indigenous rights in turn as well. Okay, about the Afghan women, first of all, together with the Special Rapporteur on in Afghanistan, Richard Bennett, we have done a lot of work on women in Afghanistan and how they are excluded. We have been in touch with the de facto, unfortunately, with the actual government that is outside Afghanistan, and we have tried to raise awareness. And if I understand well, I think that Richard is trying to get through was trying to get through the de facto Taliban government, not with so much success, I have to say. But raising awareness is important, and I also, together with Richard, has tried to raise awareness about the sport specifically and the participation of women in sports in Afghanistan, or rather their exclusion, especially as far as I'm concerned, by talking about the Olympics team coming from Afghanistan in the Olympics, where I did say that it was a big omission, that the IOC and the media did not pick up the fact that all women that took part were in the Olympics team were women living in diaspora, because actually women living in Afghanistan cannot practice sports. So there's a lot of awareness, and there's a lot of dissemination about it, but it is a very, very difficult issue in practice.
I'll put another question, which is actually touched upon by probably 3 participants, but I'll put it in a global question, and I'll probably address this first to you Yvonne in one iteration, and then to you, Dali, in a different iteration. It's to do with participation in, and also accessibility to cultural life. And how various UN agencies or institutions are facilitating this. And it's one was mentioned was UNESCO. I'll put the UNESCO question to you, Yvonne, because you've worked on both sides of the fence, so to speak. You've worked both with UNESCO, but also now with Geneva in relation to this. How do you see the issues there over now many decades? Yeah.
No, it remains a great challenge, and indeed participation is key to all of these issues. But participation should be really a sort of meaningful participation, right? So it's no longer only sort of passive access and well, do whatever you like. I think governments and states cannot get away with just saying, well, everything is open, everything is possible. There should be active, sometimes measures taken to promote participation by specific groups who might not automatically find their way into these things. I saw briefly in the chat somebody mentioning elders, somebody mentioning people with disabilities. I mean, there are indeed these groups that perhaps need some special measures in order to have the same level of participation. But very often you see that states tend to be quite passive and say, well, it's formally open to everybody. There's formally no discrimination, but that doesn't mean that everybody can actually access and have that participation or speaks the same kind of jargon or language or has the money, or there's many obstacles that are actually there, and whereby you have to facilitate. And the face coverage is indeed another form of where if you prohibit certain cultural aspects of people, that prevents them literally from participating either in sports or in society in general. I'm very pleased to say that the Human Rights Committee has actually, in the case against France, said that complete facial coverage shouldn't be banned, whereas the European Court said that it could be. Now, unfortunately, our views are not legally binding, so you get into this legal nitty-gritty, but I was very pleased that we gave that statement saying, you prohibit people also from participating in a lot of things if you prohibit them from wearing or addressing or performing certain cultural aspects of their lives. Let me leave it there.
Dali, I'll put the same question to you because you already mentioned about UNESCO and that endless conflict of trying to get them to engage in relation to human rights. The question also addressed other UN agencies such as UN Habitat, and I think some of that around environmental concerns is also problematic and continues to be an issue.
Well, I think that the point that Yvonne just made makes me think of the area of relative equality and the taking into account culture and various different characteristics of culture and cultural identity, and ensuring that equal access in terms of effective, genuine, meaningful participation of and thank you, Alexandra, for the point about not just Indigenous peoples, but culture being broadly understood, that only through something like relative equality will you ensure participation, including that of Indigenous peoples, and understanding the again, the interrelated and interconnected nature of human rights. And thank you for reinforcing that, Yvonne. I think that one thing that has been revealed even in these three short presentations is extraordinary progressive development of international human rights law in favor of culture. And if one thinks about, especially Yvonne's comments just now about Article 1 and Article 27 of the ICCPR, for example, and the work that has been done by the Human Rights Committee that is in favor of Indigenous peoples, and that inspiration and interpretation that she talks about, even those developments open the door for increased effective participation of many, including Indigenous peoples. And I'm not sure if I'm actually answering your specific question, but I think that there have been important developments that have to be seized upon. And this is one reason why I admire our Sami colleagues and friends across Norway, Sweden, Finland, and Russia is that they have taken up the activities at the international level as an expression of their self-determination and utilized many of these important pathways for recourse at the international level by invoking their human rights in ways that help to illustrate the important dynamic elements of culture. And again, just to say that it's extraordinary that Indigenous peoples have found this pathway, but indeed it is open to all others, so that we're not creating that silo, I guess. Alexandra, you probably had a different way of, or you have a different way probably of describing the separation between arts and culture that too often happens for those that may not have a ethnic identity, a cultural identity, for example. But I've strayed far away from your question, and I'm unsure if I even answered it.
Not at all, not at all. It's always on point. I'm looking at one of the final questions there, which I know would open up a whole different discussion, which would be wonderful. Unfortunately, we don't have the time, and I'm conscious also that of the various time zones in which we are in, and also that colleagues have other obligations. So maybe we'll come back to that final question in relation to reparations, in relation to culture, some other time. But for now, let me thank all three of our panelists, Professors Donders, Dura, and Zantaki, for this timely and broad-ranging discussion of our themes today on culture and human rights law. As the international community commences its revision and updating of the Sustainable Development Goals, continuing efforts to effectively address the climate emergency, or the various international and civil conflicts around the world, and the role of culture in all of these phenomena and initiatives. The urgency of these concerns has been made clear by the discussions of the recent work of these important UN human rights bodies and the developments internationally and regionally, and it has been reinforced obviously by the wonderful questions of our participants. We are grateful to our panelists for their time and insights. Participants, and I should, and Dali ended with that, just to reinforce that each one of our panelists has invited people to participate in the work of their bodies, which is vitally important, that both small and large community organisations engage with those bodies while they are still available. We often take these for granted, unfortunately, but they've been hard fought for. So participants are reminded that the link to this video, which is this webinar has been recorded, will be provided to all attendees in coming days. Thank you all for joining us this evening or this morning, whatever the case may be. Thank you very much.
Thank you, Anna.
Thank you.